Hello. Good evening. Good evening. Okay, shout out to I still don't know what names I'm giving y'all, but shout out to my my court reporters and my jurors and my prosecutors. Shout out to y'all for sending me the story. Uh Beautiful Miami J and Professor Purple Queen. Hey, Miss Lady One with the Virgo lips. Miami J, number 3 on the likes. Hey, Bonnie Mason, number 1. Oh, Miss Lady One said she was number 1. Okay. Bonnie said I was number 2. Okay, so well, we're on camera today. I had done a twist out. The twist is gone from the out, but we're still here. Okay, Haley's grandma plus 1. Let's get into this story. So the headline is Young Thug trial. Prosecutors seek to revoke YSL defendant's probation. So we're going to read it through the article first, then we'll read the actual filing. And I feel like we all knew this was coming. They took it very personal, and we'll just see what they say, because I saw the headline, I grabbed the article, and I grabbed the document, and then I was like, all right, let's talk about this. Oh, Mounk Tounk. Okay, so this is what the article says. It says the Fulton County District Attorney's Office has filed a motion seeking to revoke the probation of a former co-defendant of Young Thug, alleging that he knowingly and willfully violated his plea agreement when he testified last month. Antonio Sledge, also known as Mounk Tounk, entered a guilty plea to conspiracy to violate the RICO Act and possession of a firearm by a convicted felon back in December 28, 2022. He was sentenced to 15 months probation. As part of his plea deal, Sledge agreed to testify truthfully at trial. The DA alleges that Sledge violated his plea agreement after he took the stand and disavowed facts he had sworn were accurate and true when he took the plea deal in December 2022. In the motion, prosecutors argued that Sledge had the opportunity to review, correct, or clarify any statements within the plea deal's factual acknowledgments before affirming them under oath. Sledge said at the time that he fully understood the agreement and had discussed it with his attorney, prosecutors said. Most importantly, the defendant acknowledged that he understood that any violation of the special conditions of this plea agreement could lead to the revocation of his probation, with the district attorney recommending the maximum sentence allowed by law in the Georgia Department of Corrections, the motion reads. I'm going to say right now, this sounds like intimidation. Because I don't know if your probation, and the lawyers will have to come in and tell me, but I don't know if your probation can be revoked because you later feel like you didn't understand everything or you didn't agree with everything. They said it was an Alford plea, I believe, anyway. I'm not sure if this is the one that was an Alford plea, but they said the Alford plea was different from the other plea because you're not necessarily saying you were guilty of a lot of things. You were more saying that the state convinced you that they had most of the evidence to convict you, and so you pled out, stuff like that. So this to me, just gut-wise, no matter what the law says, feels like intimidation for future witnesses they will call that took plea agreements. That's what this feels like to me. They're setting a precedence, in my opinion. I feel like had he testified how they wanted him to, despite if he felt like he did or didn't understand something, then this would not be on the table. That's just my feeling. It says during cross-examination, Sledge acknowledged that being in the Fulton County Jail for 8 months and being separated from his sick mother and children put pressure on him to accept a plea deal on December 2022. After Sledge was done with his testimony, prosecutors called his attorney, Derek Wright, to the stand. Wright said Sledge didn't have the funds to afford an attorney for a lengthy trial and that he could not take the case himself without bankrupting his law practice. And so that's another thing. That's, to me, where the system just is not going to be there for people that can't actually stick it out for trial. I also think because the judge tied the prosecution's hands with calling calling other attorneys if other people that took pleas had a similar feeling, and they couldn't just keep examining every attorney of a person that took a plea. I think they also are doing that for that reason, since they can't challenge each attorney, which I believe they would have done if Judge Whitaker said, you're not going to call every attorney up here. Let me see here. So then it says, Wright testified that Sledge just wanted to get the plea deal done, so they compromised on the wording of some of the factual acknowledgments. The attorney later admitted that he missed the DA inserting a factual acknowledgement about Sledge having personal knowledge that YSL Associates killed Thomas. Yes, and he did. He said that the versions they sent, there was one he acknowledged he missed, but they did send they sent versions back and forth, and they did not actually point out an insertion and stuff like that. If you watch that trial day recap, full day, whatever, you could tell like it did seem like they slipped that back in there. Like it wasn't like it was just easily noticeable. You know what I mean? Like it seemed like, in fact, the paragraph was familiar to him, but I guess there was a sentence or something in there added and stuff like that. I don't like how the state's handling any of this. It says the DA's office requested Judge Paige Reese Whitaker to schedule a hearing to determine whether or not Sledge's probation should be revoked. Prosecutors say the rapper, whose real name is Jeffrey Williams, is the leader of YSL, which they contend is an Atlanta-based gang responsible for a spate of robberies, shootings, and the murders of at least 3 people. Defense attorneys maintain their clients are innocent and say YSL is simply the name of Williams' record label. Sledge was part of the 28 defendants originally indicted alongside Williams on RICO charges. He is one of 9 defendants who took plea deals before jury selection began in January 2023. Okay, let's look at this whole motion that was filed. Let me see who filed it. I need to know before I get to the bottom. They putting it on. Okay, it says Chief Deputy District Attorney Adam is the one that filed this, because you already know I was looking to see if Love's signature was on this. You already know I was. Okay, so it says, state's motion and petition to revoke probation. The state of Georgia, by and through Fonnie Willis, District Attorney for the Atlanta Judicial Circuit of Georgia, and the undersigned Chief Deputy District Attorney Adam, hereby moves this honorable court to revoke the defendant's probation in the above styled matter in accordance with OCGA 42-8-31.1 and other authority. In support of this motion, the state presents the following to the court. Plea of guilty by the defendant on December 28, 2022. On December 28, 2022, the defendant pleaded guilty to conspiracy to violate the Racketeer, Influenced, and Corrupt Organizations Act, which would be RICO, and possession of a firearm by a convicted felon. Chief Judge Ural Glanville subsequently sentenced him to 30 years of probation. The general and special conditions of probation were detailed in the final disposition sentencing sheet filed on that date, Exhibit A. Let me see. Okay, so here's Exhibit A. And so this is the final disposition, felony with probation. And there's a 30 years to be served on probation. All right. Let's go back up. I feel like this is to intimidate others from being not cooperative. Okay. Special conditions of defendant's sentence. Chief Judge Glanville imposed several special conditions on the defendant's probation, including a requirement that he fully adhere to all terms of the negotiated agreement. Any failure to comply with these terms will be considered. Ooh. Y'all know my inner seasoned lady will kick in quick. Will be considered a violation of the agreement. Of pertinence to this motion are the following special conditions. Okay, here's the special conditions. A, defendant shall abide in full by each and all of the terms of this negotiated agreement. Defendant's failure to abide by any term of this agreement shall constitute a violation of the agreement. Defendant shall testify truthfully about all matters relating to this case upon which he is questioned at any trial or judicial proceeding stemming from the facts alleged in this indictment. So B is a big one for them. C, in accordance with testifying truthfully about all matters relating to this case, defendant acknowledges that each and all of the statements contained within the defendant's factual acknowledgments section of this agreement are true. Defendant shall testify truthfully about each statement contained within defendant's factual acknowledgments and any matters related to this case when asked to do so in any proceeding related to the facts alleged in this indictment. Oh, I don't like this. I don't like this because you're more than just a rock and a hard place on this one. You have a chance to go home. You know you did some of the crimes. You didn't do all of them, but you plead to everything they put on the sheet. Your attorney fights for some, they don't let it go. And you're like, okay, this is the choice between me going home or going to jail right now. You sign it, and now you go back to jail because you did not answer the way they wanted you to answer on the stand. I don't like this. It says defendant violated special conditions of his probation. The defendant has violated all the special conditions of his sentence outlined above. On September 4th, 2024, he was called to testify in the trial of this case, with his testimony continuing through September 6, 2024, during which he underwent both direct and cross-examination. During his testimony, the defendant directly contradicted the special conditions of his plea agreement by disavowing the factual acknowledgments he has sworn were accurate and true during the plea hearing on December 28, 2022. At that moment, he had the opportunity to correct or clarify any statements in the factual acknowledgement before affirming their truth under oath. He also confirmed that he fully understood the agreement and had discussed it in detail with his chosen attorney, Derek Wright. Most importantly, the defendant acknowledged that he understood that any violation of the special conditions of this plea agreement could lead to the revocation of his probation, with the district attorney recommending the maximum sentence allowed by law in the Georgia Department of Corrections. He confirmed both in writing and verbally that he entered into the plea agreement freely, knowingly, and voluntarily without any force, threat, or coercion. It is evident that the defendant knowingly and willfully violated the special conditions of his negotiated plea agreement with the intent to disrupt the trial of this case. Therefore, the state of Georgia requests that this petition to revoke probation be scheduled for an evidentiary hearing and that the defendant be ordered to appear before this court to explain why his probated sentence should not be revoked in its entirety. Respectfully submitted this 9th day of October 2024. Oh, I don't like that. I don't like it. I think you still should have to do whatever you did for your actual crimes, but I do feel like this is one of those ones they've called it, padding a case or tacking on extra things. And I just feel like this is one of those times, like he definitely got caught doing some things, and that's on him. But I do feel like there's extras. Love was getting mad at those that didn't say what she wanted. She is disgusting and heartless. Right. Right. And he didn't have the immunity that I guess Woody had, because I feel like had Woody been brought in without that immunity, would he have the same, I'll say would he, I won't say he would, but would he have had the same petition submitted against him as well? Hey, IPV, is this lady trying to put Sexy Voice back in jail? Oh, I forgot you like Mounk Tounk's voice. Well, basically, yes, and it's being done under Chief Deputy DA Adam Abbott. I'm gonna say Abbott or Abate. Yeah, I don't. Just my own gut doesn't like this. I don't like this at all. We'll see what happens. I don't like it though. I'm not saying he didn't do some bad stuff, and for that again, I'm saying that part's fine. That's appropriate. But this seems like it's so everybody else will be scared of saying anything other than what the state wants them to say. This is terrible, Sharon. Hey, Elisa. Exactly. He didn't have the immunity that Woody had. Yep. And even that, they tried to get Woody on him saying he couldn't read, but then he read like the Hertz receipt or something. I got my hair greases all on my face. The Hertz receipts, so they might get him on perjury. Like, it could be coming with Woody too in a different form. I don't like this. Let's look at Steele filed a motion. He filed a few motions, but there's definitely one I want y'all to look at that Steele filed as well. Let me grab that real fast. Hold on. Ooh, that does not feel good at all. Let me see. Is this it? Okay, yeah. We'll start here, and we might look at the other ones. Let me see what they, because they still also filed some motions in limine too, but let me see. Let's see. Yeah, let's do this one on the expert witness one. Let's look at that one. Let me see, how much do I have? Okay, yeah, that's a 2-pager, so that's not bad. Let me see this other one. How much is this? Okay, this one's 2 pages too. Okay, so we'll look at this one. I think that's, and then, y'all, we got so much. Hold on, Ashley Merchant also filed, dang, woo, Lord, Ashley Merchant, she didn't file it. This is a memorandum that is provided by Thugger Daily too, that she wrote. I'll say that. I ain't gonna say she filed it. That might not be the right term, because it's not electronically filed like the other ones. Okay, I feel like I'm missing one. I have 65. Okay, I need 64. Y'all, it's a busy day for Attorney Steele today. It's a 60, 64. Okay. Okay. Yeah, let's see what's going on. Let's start with Steele. Get my screens back together here. Okay, so first we're starting with Steele, motion in limine number 64. Let me make it bigger. Okay, so it says, comes now Mr. Jeffrey Williams, by and through undersigned counsel, and hereby files this motion in limine number 64 to preclude any expert testimony which goes to the state of mind, intent of Mr. Williams concerning any element of any of the above referenced charges. In support of this motion, Mr. Williams shows as follows. Okay, IPV said everyone knew this was coming. That's why they are all acting the way they are with love. Hey, Mizzy Barstar. She basically set them all up to fail. You're going to say what I want you to say, or else. That's what it feels like. Hey, Regal Cameron. Okay, so this motion in limine filed by Mr. Steele and his team, his law firm, it says Mr. Williams is innocent of all charges in the above referenced indictment. In a criminal case, an expert must not state his or her opinion about whether the criminally accused did or did not have a mental state or condition that constitutes an element of the crime charged, or the defense, as those motions are solely for the trier of fact. OCGA 24-7-704B bars any expert witness from giving an opinion about Mr. Williams's mental state, intent concerning any element of the crimes charged. And he cites case law. It says, deciding whether Mr. Williams acted with a culpable mental state is solely the job of the jury, no matter how clear of proof or incontrovertible the inference, the question of whether Mr. Williams possessed a culpable mens rea must always be decided solely by the jury. Cites more case law. The prosecution bears the burden of proving Mr. Williams's mens rea, and they cannot have any witness, expert, or otherwise testify to the jury that Mr. Williams meets a material element of the crime. I feel bad too, Regal Cameron. I actually do too. Even back to common law, courts barred experts from offering opinions on the ultimate issue on the case, such as mens rea, announcing as codified in OCGA, and he cites case law again. The reason that the federal counterpart to OCGA 24-7-704B exists is because after John Hinckley was tried for shooting President Ronald Reagan and mental health experts were allowed to testify as to what was Mr. Hinckley's intent at a particular moment when he committed the particular act of shooting the president, Federal Rule of Evidence 704B removed from federal courtrooms any expert who claimed to know what was inside of another person's head, some referring to same as junk science. Over constant and continuous objections by Mr. Williams, the predecessor judge permitted expert after expert to testify that Mr. Williams and the other accused on trial were part of a criminal street gang, which goes to the mens rea of Mr. Williams and the other persons. This was total error in violation of OCGA 24-7-704B. Based upon information and belief, the prosecution is going to recall over Mr. Williams' objection for cumulative additional experts at trial who will again impermissibly read Mr. Williams' mind and state that he is a part of a criminal street gang and sang lyrics to further criminal street gang activity. Mr. Williams continues to object to any testimony that violates OCGA 24-7-704B. Wherefore, Mr. Williams respectfully requests a hearing on this motion, and at the conclusion of same, asks this honorable court to grant the above requested relief, this 11th day of October 2024. And then he also filed, hold on, do the other motion in limine first. So this is number 65. Okay, it says hold on. It says courts may permit a qualified expert to testify about jargon or code that is used by certain accused if proper foundation is laid. However, the officer's expert's testimony must not go beyond the plain meaning of the recorded communications. He cites case law. The officer's expert's testimony is inadmissible where it pertains to ordinary language, and the jurors can make a common sense determination of the evidence without the technical aid of the expert. Cites case law again. Moreover, an officer's expert's testimony may not rely merely upon hearsay testimony of a non-witness. More case law. On or about Wednesday, October 9th, 2024, or Thursday, October 10th, 2024, the prosecution announced that it intends to have investigator Viverito, a supposed gang expert who has never been qualified before this case as a gang expert or an expert in any field. Ooh, Lord, they eating Viverito up. They said they've never seen him qualified as any expert, let alone a gang expert. To testify as an expert in gangs as to wiretap conversations and what the communications meant. Mr. Williams specifically objects to this improper testimony because possibly some words which are beyond the ken of the jury may be permitted to be defined by Investigator Viverito if a foundation is laid, but Investigator Viverito cannot give the meaning of the conversation as most of the words are understandable by the average English-speaking person. Y'all, you saw it, you hear it. Y'all know Steele and Weinstein. I gotta read some of Harvey's stuff. Steele and Weinstein, they eat these people up. It says, wherefore Mr. Williams respectfully requests a hearing on this motion, and at the conclusion of same, ask this honorable court to grant the above requested relief and bar this overarching testimony where the prosecution improperly has another closing argument to impermissibly promote their theory of the case. That was submitted today as well. Then Ashley Merchant. No, sorry, Steele again. We still have Steele. Man of Steel, Steel Cajones. Okay, so then he filed motion for the entire prosecution team's file, internal memorandum, work product, all persons involved in decisions, contact information, all witnesses, and the like. I think this is maybe what he talked about at first. You think this is what he talked about on the sealed record? Like he wanted to talk to the judge. You know, he was like, I want to approach the bench first and the judge can decide if this will be sealed. We didn't recap that day yet, so y'all didn't see that through me. But if you were already watching the days, you would have seen him ask that. And I'm wondering if, because he didn't want to give them a heads up, like we're going to ask for your files. But I don't know. I'm just asking, could that have been? So it says, comes now Mr. Jeffrey Williams by and through undersigned counsel and hereby files this motion for the entire prosecution team's file, internal memorandum, work product, all persons involved in decisions, contact information, all witnesses and the like to ask this honorable court to order the prosecution to provide all work product, internal memos, emails, text messages, names, and contact information of all persons who have worked the above referenced indictment and all other information of anyone who gave statements to the prosecution team is air quoted, so that Mr. Williams can evaluate whether to voice an objection to the purported testimony of Deputy District Attorney Michael Sprinkle Esquire, that Lawyer Love stated that she wishes to elicit as to explain his reasons to indict Mr. Williams and the other accused in this case. In support of this motion, Mr. Williams shows as follows. Mr. Williams is innocent of all charges in the above referenced indictment. Lawyer Love announced on October 10th, 2024, that the state will seek to elicit testimony from the Honorable Deputy District Attorney Michael Sprinkle Esquire as to his reasons for indicting this case and charging the people in said indictment, including Mr. Williams. In order to properly prepare for cross-examination of this purported testimony, Mr. Williams now needs access to all internal memos, emails, text messages, meeting notes, photographs, recordings, any work product, and the like, so that he may obtain the proper information to challenge and confront Deputy District Attorney Sprinkle's potential testimony. Okay, so this may not have come up then what I'm thinking, the other thing, the seal thing. But I haven't seen this day, because this is yesterday's. I haven't seen yesterday's day yet in court, right? But I wonder if Attorney Steele said, Your Honor, I'm telling you now, if Attorney Love is allowed to bring in an illicit testimony from Mr. Sprinkle, then I am going to ask for the entire prosecution team's memos, correspondence, because that's how he is. I've learned him. I don't know if he held this in the pocket and just filed it, but sometimes he does try to warn them, like when they try to do something else, and he was like, I'm saying it right now, I will subpoena. It was some lawyer, somebody, like if they come and try to do this, I will subpoena them. So I just wonder, I'm going to get to the day to actually see how he did it, but I wonder what if he gave them like I'm warning you now, I'm asking for everything, or if he was like, I ain't saying nothing, I'm just gonna file it. It says, by putting forth Deputy District Attorney Sprinkle's thought process on why charging decisions were made, all privileges, work product, internal thoughts of the entire prosecution team must be deemed waived in order to permit the constitutional right to cross-examine. It is odd to fathom that this testimony would be admissible under OCGA 24-4-401, 24-4-402, 24-4-403, as same takes away from the presumption of innocence and would place the credibility of the district attorney's office on the front row for the jury to weigh. Oh, I just also was like, this could be a deterrent, because they would probably rather now say we won't elicit or ask these questions than they would actually want to turn over every note, memo, email, instant message, text message, whatever. They probably be like, you know what, we'll get to this another way. This could be just a good old deterrent type motion too, now that I'm thinking about it. Because do you understand what they could have been writing to each other, and just all the notes and things they may have that the defense would now be able to be privy to? Because that's the whole case. He's saying everything that brought you to this point for this. So, yeah, they might be like, you know what, Your Honor, we withdraw trying to elicit that from Mr. Sprinkle. Okay. And this is, if they've already done this, I haven't seen that court day yet. I have to catch up. I'll always be behind. So for those that are watching me back, like they already decided this. I haven't seen it. This is just my first reaction. Okay. It says, if this honorable court permits this testimony or is entertaining the permission of this testimony, Mr. Williams respectfully asks that he first be given ample time to review all of the above information requested and any other information that is relevant to confront Deputy District Attorney Sprinkle on why he would indict Mr. Williams. Thus, all of the above information must be released, including all thoughts of the district attorney's office, the police investigating this case, all witnesses, and the prosecutors. Without same, there can be no meaningful cross-examination of Deputy District Attorney Sprinkle on these issues. I think he's pointing out how ridiculous this is. Like, they don't actually, I don't think they actually are are looking to get this, unless they actually still try to go through with it, unless the state still tries to go through with this. I don't think still they're just showing how ridiculous this is and what they would be entitled to if the state's actually allowed to do this. Still, y'all are great and strategic. It says, wherefore Mr. Williams respectfully requests a hearing on this motion, and at the conclusion of same, ask this honorable court to grant the above requested relief. All right. Now let's get to Ashley Merchant's memorandum. I'll just call it memorandum letter. I'll just call it that. So hold on. All right. Now this was back on October 9th. And this is my first reaction to these documents. So I don't even know what I'm about to read, but I saw it was addressed to Ms. Love, and I want to read it. Okay, so it says, Fulton County District Attorney's Office, Ms. Adrienne Love, Assistant District Attorney. Hey, Candace. This was via email, and it says, in regards to the state of Georgia v. Williams et al., witness Martinez Arnold. Dear Ms. Love, I hope you are well. Please allow this to follow up on our prior discussions in connection with Mr. Martinez Arnold's testimony in the trial of State v. Williams et al. Given that the state has sought arrest warrants in connection with other witnesses, I wanted to proactively reach out to you regarding the scheduling of Mr. Arnold's testimony so that we may avoid any last-minute scheduling issues and avoid a legally improper material witness warrant issuing for Mr. Arnold, because you know they did that with Quindarius Zachary, Woody. I don't know if they had to arrest Mounk Tounk again before he testified, but you know they definitely issued a few of those. So she says, in an effort for full transparency, I am copying the court and known defense lawyers on this communication. So you can't say, oh, it was an unwilling witness. You know, that's what they go to. Because they said Quindarius Zachary always willingly wanted to come in and just testify to clear up some things that was said. So yeah, I don't blame them for putting everybody on notice again, because this is not the first time that they have said we just need decent heads up. Okay, so it says, in connection with his anticipated trial testimony and as part of the plea negotiations in December 2022, I requested two things. One, that the state honor my leaves as Mr. Arnold's counsel of record, and two, that the state give Mr. Arnold and me advance notice of his trial testimony so that I could comply with my legal obligations pursuant to Superior Court Rule 17.1, which requires that I provide other courts with at least 7 days notice of any conflicts. To be clear, my continued request for advance notice of the date the state anticipates calling Mr. Arnold is in no way a suggestion that he will not abide by the terms of his negotiated plea. He intends to comply with the terms of his plea, just as I hope you will comply with our agreement that you would provide me with advance notice of the date of his testimony. While I have not followed the proceedings closely, I understand that the state recently has sought material witness warrants for certain witnesses, and my belief is that the state has done so without legal authority. I believe the state's arrest of Quindarius Zachary on September 16, 2024, constituted a false arrest and would give rise to civil action against you and others who effectuated his arrest. The order, she mentioned Quindarius Zachary in here. The order your office presented for Judge Whitaker to sign references an application for an arrest warrant for a material witness with a criminal offense of OCGA 17-7-90. That statute, however, does not apply to witnesses, but only applies to criminal defendants and whether they appear for their own cases. So again, that was not the first time I heard that. I heard that applied to people that were actual defendants in a trial and not just someone that was supposed to show up as a witness to a trial. I heard that, and she's putting it right here that they did not even do the warrant under the right criminal offense. For these reasons, I am writing proactively to ensure you do not improperly seek a material witness warrant for Mr. Arnold. If you do, we intend to seek all remedies under the law as I outline below. Oh, yes, please outline them below for us. Hey, Keisha. Hey, Purple Unicorn. Hi, everybody coming in. Okay, so It says, as I am sure you understand, there is no mechanism to obtain a material witness warrant for an in-state witness, but the state recently has sought such warrants for in-state witnesses. Material witness warrants are permitted in two instances. First, pursuant to OCGA 17-7-25, attendance of witnesses, a court of inquiry shall have the same power to compel the attendance of witnesses as in other criminal cases, as set forth in and subject to all of the other provisions of Chapter 13 of Title 24, at any location where the court shall conduct a hearing, provided that notice is given at least 24 hours prior to the hearing. A court of inquiry may order the arrest of witnesses if required to compel their attendance. 17-7-20 explains that a court of inquiry is a court with the criminal jurisdiction of a magistrate to examine an accusation against a person legally arrested and brought before him or her. These provisions clearly do not provide for the issuance of a material witness warrant before a superior court conducting a criminal trial. The second instance that a material witness warrant may be issued is when a witness is from without the state, pursuant to the Uniform Act to secure attendance of witnesses from without the state, OCGA 24-13-90 et al. As Mr. Arnold is not a witness from without the state, this provision also does not provide for the issuance of a material witness warrant for Mr. Arnold. This email is a one big, I wish you MFN would try to put a warrant out for my client. Baby, I'm coming at you. That's what this email is. It says, while the court retains the power to compel the attendance of witnesses, that power is enforced by attachment for contempt and not a material witness warrant. OCGA 24-13-26. Subpoenas are enforceable by attachment for contempt and by a fine not exceeding $300 and or imprisonment not exceeding 20 days. In all enforcement cases, the court will consider whether, under the circumstances of each case, the subpoena was served within a reasonable time, but in any event, not less than 24 hours prior to the time that the witness's appearance was required. 15-1-3 provides general powers to the court to enforce compliance with this process. Clearly, the state has no power to seek a material witness warrant for an in-state witness at a trial before a superior court judge. The only power the state has to compel the attendance of a witness is contained in OCGA 24-13-26, which is not applicable at this time since Mr. Arnold is willing to appear even without a subpoena. This woman is always being taken to law school. And when I say this one, I mean Love. Love is always being taken to law school. While district attorneys typically enjoy immunity for acts undertaken in connection with their court-related duties, the 11th Circuit Court of Appeals recently denied absolute prosecutorial immunity for a Fulton County district attorney who obtained a material witness warrant for a witness and then failed to recall the warrant after the witness testified. Oh, hold on, y'all. Let me reread that sentence for you. Right now, what she's saying, while DAs in general enjoy the privilege of having immunity for their acts in connection with a trial. So she's saying, while you, Attorney Love, typically enjoy immunity for acts that you have undertaken in connection with your trial, your court-related duties, that's not going to be the case on this one if you mess this up. She said the 11th Circuit Court of Appeals recently denied absolute prosecutorial immunity. So immunity for the prosecution, not a witness for the prosecution, the actual attorneys of prosecution, for a Fulton County district attorney. So within their county, who obtained a material witness warrant for a witness and then failed to recall the warrant after that witness testified. So they left the warrant open. Cass v. Fulton County, Georgia. So, baby, she's saying, hey, you will not be immune if you mess this up. Love, she's talking to Love. The court held that the arrest and confinement of the witness had nothing to do with conducting a prosecution for the state, and that the DA did not have to engage in advocacy to initiate the warrant's recall, but only needed to notify the judge. Therefore, the district attorney did not have immunity for the false arrest and confinement of this witness under a material witness warrant. If you choose to ignore the foregoing law and seek a material witness warrant for Mr. Arnold, we are putting you on notice of our intent to pursue all remedies provided for false arrest and confinement as outlined in the Cass decision. We truly hope that is not necessary. Yeah. Oh my gosh. She says it again because it's hard to get stuff through to Love. She says, I wish again to make clear that Mr. Arnold intends to comply with his obligations under his plea agreement, which included his rights against self-incrimination under the Fifth Amendment and the right to have me present in the courtroom with him when he is questioned by the state. I am simply requesting that the state, as it agreed to do, provide me with advance notice for his testimony and honor his privilege against self-incrimination. Though we have not been able to talk about this in person given our schedules, I hope this clarifies my position regarding Mr. Arnold's testimony, and I look forward to your anticipated cooperation. Baby. Oh, child, I hope nobody from my job ever eats me up in an email the way this email, child. Oh, this is... She's not only stated the reason her client better not ever have a warrant issued for this reason, she also said, and I will come for you in every remedy that I am afforded. I'm coming for you. I'm coming for that behind. Woo! Woo! Jesus. Lord. But I get it. Oh, I get it. And then is she gonna have to write another let me warn you real quick email? Is she gonna have to write another one now that she sees that they're trying to revoke Mounk Tounk's probation? Like, is she gonna have to cite some case law about don't come for my client about they didn't testify the way you wanted to? Oh, if you go after their probation for this, ooh, wee. Yes, I remember. I feel like this is the repetitive times that Love is acting like they don't get it, that she had to put it in writing and put everybody on notice. Let me see who on notice. Judge Paige Reese Whitaker, Judge Simone Hilton. No, sorry, not Judge, but Attorney Simone Hilton, Adam Abbott, Brian Steele, Keith Adams, Max Sharp, Doug Weinstein, Jay Apt, I don't know how to say that, Bruce Harvey, that's YSL Ponytail, Carson Matthews, Lamar Gardner, Angela Williams. Hey, beautiful Joyce Miles. Oh, the judge told her, I don't think you want to put her on the stand like you did with Sledge, attorney, because that didn't work out well for you. Yes, I remember. I wrote that down, had to timestamp it, Plans and Pens. I didn't know at the time she was speaking about Ashley Merchant, and I did not I don't want to get too much into Ashley Merchant because of the other stuff I can't talk about till after the election. But no, Love, this is not the one you want. This is not it. This is not it. Ooh, y'all. Okay, I still got to finish up my notes for Wednesday, and then of course I got to watch what happened today. But hopefully we will get to it this weekend where we can go over at least Wednesdays, and then since we have Monday off because of Columbus Day, I should be able to catch up for what happened today too. See, it all boils down to them not saying what she wanted them to say. She chose those witnesses. They can't stand her shady behind me either. Yep. Sharon said they have been warned. They have. And here's the thing. She specifically, for the prosecution, she's addressing Adrian Love. This is not to Atkins. This is, well, I guess it kind of is. It's to, well, Hilton's on here. I don't see Atkins' name on here, actually. But Hilton is on here. I see Hilton. But baby, this is for you, Love. This is for you. When Ashley came in court to defend Steele against the contempt and taught Glanville the law, honey, she shut Ish down that day. We're gonna have to do a rewatch, Plans and Pens, because see, I didn't get to be there with y'all to watch that. So we're gonna have to have one of these days. It's gonna be out of order, but we're gonna have to watch when she came into court and stood up for Steele. Wow. Okay, y'all. That's all I have for now. Did you see that email that was sent to Love? And Fanny's response, the judge was not happy. Is this, wait, a different email? Not Ashley Merchant's email that I just read, Keisha? A different email? I didn't see it yet. Hopefully I can come back across it and then we can talk about it. Oh, I like these. I like these. Oh, these are nice. Okay. I'll probably clip this up possibly because I have it only titled about Mounk Tounk in this one, and the title's already like super long and the thumbnail's done. So I might clip these up. So if you see a repeat, it's because I clipped it up so I could actually title it what each section was about, a different one. Okay. I am on the lookout for it then. Woo. It's spicy out here. Okay, y'all, but I'll get off for now. I thank you for your time. I'll talk to y'all soon. All right, bye.